We are present in Nashville, Tennessee for a hearing before the Tennessee Board of State Private Investigation and Polygraph Services. We're here to consider the matter of William Curtis Burkett, docket and Burkett and Associates investigation, docket number 125154A. I am Lynn England, and I've been assigned by the Secretary of State to serve as the administrative judge in this proceeding. I will make all rulings of law, evidence, and procedure. I will determine the admissibility of evidence and any other matters that have been bestowed upon me pursuant to the Tennessee Administrative Procedures Act. In other words, it's my duty to conduct the hearing and regulate the course of the hearing. I will not participate in the findings of fact or the ultimate decision made by the members of this board. These decisions will be made by you. At this time, I will ask each member of the board to identify yourself for the record.
David Brown.
Walt Valentine.
Jerry Richards.
Minnie Lane.
Larry Flair.
Rick Jones.
David Horton.
Ms. Chairperson, do you have a quorum?
We have a quorum.
Thank you. The state is represented today by Ms. Robin Ryan. The respondent, Mr. Burkett, is not present nor represented by counsel. Ms. Ryan, what proof of service of notice of this hearing do you have?
Thank you, Your Honor. This matter was filed on March 18th and was sent to the respondent via both certified and regular mail. The mail was signed for on 21st of March by, I can't quite read it, but somebody looks like it might be Deidre Burkett. But the green card was signed for. We have heard nothing following that statement, except that I did send a witness and exhibit list on April 23rd and a motion concerning telephonic testimony on the same day. Neither of those items were returned either. Additionally, our paralegal called the most recently, the 8th of this month, left a message on the number we have, and did not hear back. Yesterday, I received in my office a letter dated May 5th, but not postmarked till May 13th, saying that he was requesting a continuance because of the date. Additionally, I have received in my office a letter dated May the 9th, and a letter also postmarked May 13th, and another letter dated May the 9th, also postmarked May 13th. May 14th, one of which is a list of witnesses he planned to present, and one of which is a denial or a request to deny the telephonic evidence. Additionally, Mr. Burkett called at 7:08 this morning and left a message on my voicemail concerning today's hearing. Our paralegal did attempt to call him back at 7:51 this morning, left a message. We have not heard back from him. Therefore, Your Honor, I would ask that this court find that there is sufficient service, and with the green card entered as evidence, as well as a copy of these letters and their postmarks as evidence, I'd ask for default judgment.
I do find that the respondent has received legally adequate notice of this hearing by certified mail received March 21st, 2014, signed for by a Deidre Burkett on March 21st. In addition, by evidence of correspondence from the respondent, it is obvious that he did have proof of notice of this hearing today. Ms. Chairperson, pursuant to Rule 1360-4-1-.15 of the Secretary of State's Rules of Procedure for Contested Cases, the board must now decide whether to grant or deny the state's motion for a default. I'm going to enter the the green card and the other letters into evidence and identify them as collective Exhibit 1 as proof of service of this hearing, proof of service of notice of the hearing today. Let me instruct you that if you grant the motion for a default, you may either pardon me, adjourn the proceedings, or you may conduct them in the absence of the respondent. If you grant the motion for default, we will go forward with the hearing today. Or you may determine to go forward with the hearing on another day. I will turn it over to you for a vote on how you want to proceed.
Make a motion that we do accept the ruling on the default.
Mr. Chairperson, we can't hear you.
Oh, I'm sorry.
That's okay.
You need a motion to go forward today and accept what was presented to us now. Is that correct? Hey, I'll make that in a formal motion, please.
And I'll second it.
Motion was made by Commissioner Flair and second by Commissioner Horton. Is there any discussion on this motion? Point out, we don't have a full board if we want to take that into consideration.
As long as you have a quorum, you're fine. Yes, ma'am, so you'll just vote.
According to his motion, we will be going forward on
Today.
default. Today.
Yes, ma'am, and you want to have a hearing, was his
Is that what
motion,
you
is that correct?
That's what his motion was. All in favor?
Aye.
Opposed? Motion carried.
Thank you. Members of the board, you're reminded that during this time, no discussion concerning this case shall take place between members of the board, judges, witnesses, attorneys, or any other persons unless all parties are present. During the hearing, you will sit as a jury. You will only consider the evidence that's introduced at the hearing in reaching your decision. The Tennessee Sunshine Law, or Open Meetings Act, requires all discussions and deliberations by the board be made in public before the parties. Failure to observe this instruction will likely result in your decision being reversed or remanded if appealed to Chancery Court. Members of the board, the law requires you to disclose on the record any outside knowledge of this case or any communications, whether written, verbal, or otherwise, from anybody concerning this case today. Does anyone have anything to disclose regarding this matter?
Could I ask, is it proper for me to ask, the name is familiar, what area of Tennessee? Or if-
You may, they're from I think they're from East Tennessee.
That's Tennessee,
But the question is, do you have any prior knowledge
of the facts.
of the facts of the case? And if so, you're required to disclose them. Okay, today we will begin with opening statements. Then you will hear the evidence. The evidence generally consists of numbered exhibits and testimony of the witnesses. The state carries the burden of proof in this matter, so the state will present their proof first. The respondent, though absent, the state's still required to present their proof, and you have to make a determination. During the course of the hearing, there will be an opportunity for each of you to question any witness that testifies under oath. You may use your questions to gain information that you feel would assist you in reaching a decision in this case. However, reserve any expression of opinions you may have on the facts until the portion of the hearing which is set aside for your deliberations. Once the evidence has been presented to you, then the state will make her closing argument. Please remember that statements made by counsel are not evidence. Statements are made only to help you understand the evidence and apply the law in the case. Once closing argument has been made, I will then instruct you on the rules of law that apply in this case. It is your function as members of the board to determine what the facts are, to apply the law, to make conclusions of that law, and decide if any violations have occurred and what proper discipline is or should be taken against the respondent. Are there any preliminary matters?
Your Honor, I would ask permission, please, to pass out a copy of the notice of hearing and charges to the members of the commission.
You may do so.
Thank
Ms. Ryan, while you're doing that, I will identify the technical record. Technical record in this matter consists of the notice of hearing filed March 18th, 2014, a pre-hearing order issued March 27th, witness and exhibit list filed by the state April 23rd, motion to have witnesses appear by telephone filed April 23rd, an order issued granting the motion May 8th, a letter from Mr. Burkett filed May 15th, a request for continuance filed May 14th, and Mr. Burkett's witness and exhibit list filed May 15th. Without objection, this shall be the technical record up until this point.
No objection. Your Honor, before we go any further, let me ask that each of the commissioners be sure to speak in the microphone because we can't pick it up any other way. Good morning. The matter is before you today on a complaint filed by Mr. Ray Stanton. He will tell you that he paid $500 to Mr. Burkett and Crow's Nest Burkett investigation. Sorry, I had another hearing earlier this week. For investigative services. You will learn that the check was from Mr. Stanton's attorney, written on her escrow account, and was cashed. Mr. Stanton will tell you that no work was provided at all, no accounting was made to Mr. Stanton, and no report was sent to either Mr. Stanton nor his attorney. You will hear that Mr. Burkett wrote a letter to Mr. Kilgore, the commission's attorney, stating that these allegations were false, that he had a signed contract and a report he would provide, but nothing has been provided. Even as of today, nothing has been provided, despite promises that there are in some indication to support his point of view. He has provided nothing. You will hear that Mr. Stanton attempted on several occasions to contact Mr. Burkett to no avail. It is the state's position that these actions are a serious violation of 6226, 2312, wherein it provides that no private investigator nor investigation company shall make unsubstantiated monetary charges for a client for services not rendered. And Rule 1175.046, wherein it states that a licensee shall not bill a client for services not provided, and that a licensee must provide a person a itemized statement of services and expenses on that request of the client. Proof will show this does not occur at all. It is the state's position that these actions are seriously egregious. And when considering all the facts, and including, you will hear today, of his very few attempts to contact this commission, this body, or prepare for today in any serious way, that this is serious. It is our position that is a serious violation, and we ask that at the end of the hearing today, you consider all of this and revoke his license, require him to pay a civil penalty, and require him to pay all the costs involved in the hearing today. Thank you.
You may call your first witness.
Call Cody Vest. Yeah, Cody, yeah. And I don't believe she's been sworn.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you, ma'am.
Would you please state your full name?
Cody Vest.
And Ms. Vest, what is your position with the state of Tennessee?
I'm the Executive Director for the Private Investigation and Polygraph Commission.
And as the executive director, what are your duties and responsibilities?
My duties are to regulate the program, see that the licenses, handle the license, make sure people get their applications filled out, get the license, and to handle all complaint matters.
And also, as the executive director, does that mean you're the keeper of the license files and the complaint files?
Yes.
Okay. As the director, are you familiar with the complaint and license file of Mr. William Curtis Burkett and Burkett and Associates Investigations?
Yes.
What are their license numbers?
William Curtis Burkett's licensed private investigator license number is 6495. Burkett and Associates Investigations license number is 1609.
And when was he first licensed?
Mr. Burkett himself and his company both were licensed on September the 7th, 2007.
And what are the expiration dates for these licenses?
Both of these licenses will expire on September the 30th, 2015.
Does that mean they've been renewed recently?
Yes.
Okay. What is the general time period within which a license is good? 1 year, 2 years, 3 years?
This is a 2-year license.
So therefore, until the 30th of September, these licenses would be good, of 2015?
Of 15, yes.
Is there a time period after an expiration date where someone can catch up and still renew their license?
The license actually expires on September 30th, 2015, but there is a period of 30 days to where they can get back into compliance without having to reapply.
So in theory, then, these licenses could remain valid until October 30th of 2015? Expiration date, yes, but he could still get back in.
Yes, ma'am.
Thank you. Would he have to fill out a new application at that point?
Once it expired past that 30 days, which had been on October the 30th, be November the 1st, yes, he would have to reapply
Okay.
completely.
Okay. What was the reason this complaint was opened?
I established this complaint because the board office received information that he'd accepted a $500 payment from the from the attorney but for investigative services, but failed to provide any findings or any information to the client.
Did he provide any response to that complaint to you?
I have no record of the gentleman responding at all.
Was that complaint, when it was opened by your office, that was sent to him so he could respond?
Yes, ma'am, we sent certified mail to Burkett and Associates Investigations at a post office box 358, Jackson, Tennessee 37757. It was returned unclaimed, unable to forward, and then we turned around and we sent it to another address we had, which was his home address of 3241 Pinecrest Road, Jackson, Tennessee 37757. It was returned, it said moved, unable to forward.
Did he ever provide an additional address to your office?
Not to my office, no.
Okay. Let's go back a minute. Tell me the process. When someone files a complaint, what is the process for reviewing that complaint?
We will get the complaint in writing. It will go to our complaint coordinator. We have standard forms that we fill out. The complaint coordinator will get with myself. I'll review the complaint. I'll sign the forms. We also let our staff attorney look at the complaint as well to make sure it is our complaint. He fills out the forms, and then we will send it out for response.
To the respondent?
Yes.
Okay. Do they have a certain time period at all within which they have to respond?
I believe that letter says 14 days.
Okay. After a response is received, or in this case, when a response is not received, what happens next?
Well, we wait to a period of 30 to 32 days, quote, on the calendar, before we will send it to legal to set up the actual complaint setup. Excuse me, I should back up. At that point, we put it on our database, give it a file, a case number, complaint number, and then we'll send it up to legal, to our staff attorney.
I'm going to show you a letter, please, that's dated the 9th of October, 2013. It says to the Private Investigator and Polygraph Commission by Mr. Burkett, and see if you can recognize it as a letter from your file. May I approach? Do you recognize that letter?
I have seen this letter, yes.
Okay. And does it have an address on it?
Well, this one, yes, it's dated 10/9 of 2013, which was received in our office 10/16/2013, and it says he's changed my contact information and has given us a new address.
And where is that new address?
It's 817 Ridgeview Drive, Clinton, Tennessee 37716.
Is that the most recent address that your office has of any sort of Mr. Burkett and Burkett and Associates? Do you have anything more recent than that?
I don't have anything in our files before this.
Okay. Not received. What's the next step in the complaint process? After you have reviewed it, what happens?
After I reviewed it and it's gone to legal, then it's presented, the legal staff will present it for a legal report for the commission meeting.
Is that done anonymously?
Well, yes.
Okay. What laws govern actions complained of by this particular complainant against this respondent?
Bear with me. I regulate several other programs, so I'll have to read this. I don't remember them. I have 6226221, which is under the violations number 2, make unsubstantial which is no individual licensed as an investigations company or private investigator in Tennessee shall make unsubstantiated monetary charges, to a client for services not rendered or transportation not utilized.
Are there any rules that also apply in this matter?
Under 1175-4-.06 under misconduct, number 4, the licensee shall not bill a client for services or expenses which have not been provided or incurred. A complete and comprehensive itemized statement of services and expenses must be provided to the client upon request.
Are these the allegations that were sent out in your original complaint sent to him?
Yes.
Okay. And again, did he provide any information to say this wasn't true, or that he had documents to show it wasn't true?
My office has not received any documentation from Mr. Burkett.
I'm going to show you a copy of the complaint and ask you if this is a copy of the complaint file, if I might, and ask you about certain documents in that complaint. Copy of the complaint file in this matter? Can you look through it?
Give me just a minute, let me make sure. Yes, ma'am, it is.
Thank you. On the complaint drafted, or the words of the Mr. Stanton, don't read them, but just tell me in essence what he is saying happened in this matter. That would be the basis for your complaint state.
They accept that the investigation company accepted payment for services not rendered.
Okay, and if you look at the back of the complaint file, can you see if you can find a letter dated December 1st, 2013 from Mr. Burkett?
What date again?
December 1st, 2013.
Yes, I have one.
Can you please read that letter that is from Mr. Burkett?
Okay, it's in reference to a Tennessee Pride Investigation Polygraph Commission case number L13 PIC RBS 201-3000-3591 and case number L13, which would be the company. Dear Mr. Kilgore, I have reviewed the documentation that you sent me, and I must admit I'm shocked. I will in no way concede to these allegations. These allegations are extremely serious and completely untrue. I have never had the opportunity to present proof of these allegations are false, and I request the opportunity to do such. I have in my possession a signed contract, a copy of the original reports, as well as phone records that show the interaction between myself and my accuser. I also have and will now attempt to locate an audio recording of a conversation between myself and your complaint, in which he threatens myself, my life, the life of my children, the life of my wife. He made these threats because he was mad that the investigation did not reveal that his wife's new boyfriend was a person of bad moral character. His own attorney, Miss Christy Anderson, advised me not to give Mr. Stanton the physical address of his girlfriend's boyfriend due to Mr. Stanton's mental state. I acknowledge that after the threats, I would not personally meet with Mr. Stanton, as it was unnecessary to expose myself, my family, and Mr. Stanton to the opportunity of a violence to take place. I would be happy to fax, mail, email you the above-mentioned documentation. If we are unable to resolve this, I will be required to obtain counsel to represent myself and my company at any formal proceedings. Thank you for your attention and help in this matter. Respectfully, W. Curtis Burkett, Burkett & Associates Investigations, and then the address.
And the date of that matter, please?
December the 1st, 2013.
Okay, that was this just past December.
Yes, ma'am.
To your knowledge, were any of those documents ever provided?
I've never seen any
Not
of
at
these
all.
documents.
On the next page, or the very last page of the complaint, it looks like dated 4/1/2013. There might be a check. Can you locate that?
Yes, I have a sheet here that says 4/1/2013. It's a check from Christy N. Anderson, attorney at law, made payable to Burkett & Associates, then in parentheses Curtis Burkett, for $500, signed by Christy Anderson, and the description, it says it's for Stanton versus Stanton.
And has that check been acknowledged and signed for by someone saying they're Curtis?
Yes, it's signed on the back by sort of Stanton, yes.
And I would like now to enter this complaint as the first exhibit and ask that I be able to present that to the commission for their review. Yes, Your Honor. Him first. Okay. It's one exhibit. It's one document.
Document, okay.
I have nothing further at the moment for this witness, Your Honor.
Members of the board, do you have any questions for the witness?
Yes. Have we had any contact with or from the attorney, Christy Anderson, to find out what she has to say about this?
I have not. That is be a question for legal.
She'll be, I believe she's on the witness.
He is on the witness list.
Other questions?
I had one comment.
Commissioner Valentine?
I noticed that you said Jackson, Tennessee, and it's actually Jacksboro,
Oh,
Tennessee.
I beg your pardon.
Thank
Stand
you.
corrected.
I've been racking my brain trying to figure out who this guy
I'm
is and
sorry.
where he lives.
Thank you for correcting me.
Any more questions? You may step down, Ms. Best. Thank you.
Your Honor, the next two witnesses, we will be having appearance by telephone. The first one will be Christy Anderson, and we will then need to call her and attempt to get a hold of her. That'll take us a minute or two.
You need a short recess?
Yes,
5-minute recess?
very short. No, see, I'm going to
Back
turn
on
you
the
over to
record.
the judge for the moment to let her clarify what we're doing.
Okay.
Hello, Ms. Anderson. This is Judge England. Let me swear you in at this time. Do you solemnly swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Just to let you know, once you've completed answering the questions of Ms. Ryan, the members of the board that are present today may have questions for you.
Okay.
Okay, thank you very much.
Thank you.
Your Honor.
Thank you for agreeing to appear today via telephone. Could you please state your full name?
Christy Nicole Anderson, and that's Kristie.
And where do you live, Miss Anderson?
I live in Campbell County, Tennessee.
And what do you do in Campbell County, Tennessee?
I am an attorney.
And how do you know Mr. William Curtis Burkett and Burkett and Associates?
From time to time, I have, through my clients, employed his services to do different things for certain clients.
And did you have an occasion to use him for a Mr. Roy Stanton?
Roy Staten, yes, I
Yes.
did.
Okay. When was he hired?
I can tell you, and I can look back, I wrote a check for him. I will tell you the exact details of it are really, I didn't necessarily I set up the meeting between Mr. Staten and Mr. Burkett. I allowed them to have the communication and allowed my client, Mr. Staten, to determine whether or not he wanted to obtain Mr. Burkett's services to do what we needed to have done. Or to do what he needed to have done, and he said that he did. So he brought money to my office, which I then turned over to Mr. Burkett.
And I do have a copy of that check, and it appears that it's dated 6/19/2012. Does that sound about right to you?
That does. If that's a copy of the check, I would have provided that, I think, to you all.
Okay. And of course, it came from your escrow account. That's how you have a track of that. Is that right?
That's correct. It would have been out of my trust account.
Did you have any contact from Mr. Burkett concerning this matter?
I did, on at least, and I can't tell you, quite frankly, on several occasions I attempted to contact Mr. Burkett. He told me at one point he was working on it, and he was going to have the information, and from that point, he quit taking any phone calls. He would not answer any telephone communication from me through my office. I attempted to contact him through my cell phone. And I do not want to state incorrectly, but I think I may have attempted to contact him once from maybe the clerk's office, and he may have answered that number, but I cannot tell that as a definite truth.
Was the work completed?
No, well, I don't know. He never provided anything.
Did he provide you with any copy of invoice or anything concerning this matter?
No, he did not. He never provided anything to my office, which was normally what he would do. In the past, when I had used him or my clients had used him for any services, he would normally provide any documents or anything that he was doing. He would normally provide that to my office, and then from there, I would forward that on to my clients, or we would do with it what we needed to do with it as far as preparation for a case.
But in this case, you did not get anything from him.
We received absolutely nothing, and he has avoided all communication from my office. I believe I ran into him on one occasion at the courthouse, and he attempted to avoid me, in my opinion. And I talked to him about this case, and he, I believe, told me that he had the work done, and I said, well, and this was way past the point of when the work needed to be done, and it was of no use to me at that point. And I said, well, it doesn't do us any good at this point. But he was trying to avoid me, and I doubt that he even had the work done. And he, like I said, he wouldn't take any phone calls.
Thank you. Now, you said earlier today that you had used him in the past.
I had from time to time.
Do you still send anybody to him?
No, absolutely not.
Okay. I have nothing further for this witness, Your Honor.
Members of the board, do you have any questions for this witness?
Yes. Ms. Anderson, did you at any time ask him not to contact Roy Staten?
No, I did not.
Other questions? I have one. Was there a contract between the attorney, or was the contract between your client and Mr. Stanton?
Typically, what was done, and to be honest with you, and this is probably, you're going to say you're an attorney and you should have done something differently, but I never obtained any contracts with Mr. Burkett when I did any work for him. If he obtained contracts, it would have been with my clients. It was never through me. I typically just placed the money in my trust account and would write the check out, and I would confirm what we did or did not need.
Thank you. Any other questions? Commissioner Flair?
Larry Flair, Ms. Anderson, do you know if this individual is still practicing any type of investigative work at this time in your area?
Well, I have not seen him in Campbell County at all since this happened. Well, other than the times that I've told you all, I do not believe that he's receiving any work in this county. He did in the past. He had, appeared pretty regularly here and there, but I've not seen him with anything in this county since. And I can't tell you what I've heard other things, but I can't, as far as to say with certainty on anything else, I cannot. But I can tell you that I'm regularly in Campbell County courts, and I have not seen him on any matters since.
This is Walt Valentine. I had one other question for you. To the best of your knowledge, did he have a contract with your client?
To the best of my knowledge, I do not believe there was a written contract, and I do not believe that Mr. Burkett, to the best of my knowledge, had written contracts with any of my clients in the past.
Thank you.
Other questions?
Any follow-up?
No, Your Honor, but I thank Ms. Anderson for taking the time to testify today for us.
Thank you, Ms. Anderson.
Thank you, Your Honor.
Yes, ma'am. Bye-bye.
Bye-bye.
Bye.
The next witness I'm going to call, Your Honor, is Mr. Ray Stanton, and we also will need to call him.
Hello.
Mr. Stanton?
Yes, ma'am.
This is Robin Ryan calling from the Tennessee Department of Commerce Insurance, and we are in the process of the hearing today.
Outstanding.
And I'm going to turn you over to the judge for swearing in.
Yes,
ma'am.
Mr. Staton, this is Judge England. I'm going to swear you in. Do you solemnly swear or affirm the testimony you will give today will be the truth, the whole truth, and nothing but the truth?
I do, Judge, Your Honor.
Thank you very much.
Thank you. Could you please state your full name for the record?
Roy Wayne Staten,
And Mr. Staton, what's your address?
434 Bluff Trace, Jacksboro, Tennessee, 37757.
Thank you. How do you know Mr. Burkett, Mr. William Curtis Burkett and Burkett and Associates?
Mr. Burkett was hired to find out about a specific individual in Knoxville, Tennessee. So we hired him, myself and my attorney, and he was hired just to give a printout and a background check on an individual.
And did he do that?
No, Your Honor, he did not.
And was there any written contract between you and Mr. Burkett or Burkett and Associates?
Yes, I believe there was. If there was, of course, it would be with the attorney, Your Honor. I actually met Mr. Burkett face to face.
Okay. And in that meeting with him face to face, did you discuss what was needed?
Yes, Your Honor, I did. I absolutely did.
And did he tell you what he planned to do and what kind of reports he planned to give you?
Yes, and he actually spoke to me about a month later. He said that the report was ready, that he just needed to turn it in, and it was all completed. He and I spoke about finding out about a specific individual that was around my son, and I wanted to know about that individual. I wanted a report, and I said also if he would just give me his personal opinion about the individual and about the attorney that my wife had been around in Knoxville also, because I know the attorney had a record. And I said, just give me your personal opinion and give me a report. He said that he would.
Was any report provided to you at all?
No, Your Honor, nothing.
Was
Nothing.
there an invoice provided to you?
No, Your Honor. I never received anything, and he just stopped returning my phone calls.
Have you been able to contact him at all?
No, Your Honor, not at all for over a year. I've been contacted by attorneys in Clinton, Tennessee, that are also interested. They knew of my dealings with Mr. Burkett, and those attorneys contacted one specifically, other attorneys, and he asked how that was going. I assumed that Mr. Burkett had also had dealings with him also, and I said I didn't know his whereabouts, and no, he did not complete the job.
Did he give you a refund of the money you paid?
No, Your Honor, he did not.
Did you ask for a refund of the money you paid?
Absolutely, Your Honor, I did, but of course he stopped answering the phone.
Okay. Have you had any recent contact at all in the form of a letter or a phone call or anything in the past 6 months from Mr. Burkett?
No, Your Honor. No letters ever, Your Honor.
Thank you. I have nothing more for this witness.
Mr. Staton, members of the board may have some questions for you at this time.
Yes, ma'am.
Mr. Staton, I'm Minnie Lane, chairman of the board, and I have one question. You said you requested a refund. How was that requested, in a conversation or a letter?
Over the phone, Your Honor. Oh, excuse me, ma'am. Over the phone.
No problem. Is there any other questions of the commission?
Mr. Staton, thank you very much.
Thank you.
Thank
Bye-bye.
you. Goodbye.
That concludes the state's proof, Your Honor.
Do you have closing remarks?
I do. You've
And
heard
do you-
today how this licensee took money. No question about it. He took a $500 check. You have a copy of that check. This licensee made promises to do a job that affected this particular person's life. He promised to provide a report. He did not provide that report. He did not provide anything. And moreover, he's not bothered to communicate at all. And not only with this person, but with this body, he is not bothered to communicate. This is someone out there doing a job that affects more than this particular person, but other people. He's out there with a license saying that he can do private investigations and apparently take money and not do the job. This is exactly the kind of person we do not want practicing in the state of Tennessee. I would show that these actions are in violations of the statutes that read earlier, and they are in violations of the rule, and that without taking his license, we cannot be assured that he won't do this again. We can't even be assured that there aren't other complaints pending for the same thing. This is somebody who has no concept of honoring law or honoring contracts, and he should not be practicing. I'm asking you to consider everything you heard today and find that he is in violation of these laws and rules, and find that he should have no license, and ask that you revoke his license. You may also assess a civil penalty for the violations under the statute. You may also, and I ask that you charge him with the costs of having this hearing today. Thank you very much.
Members of the board, it is now my duty to charge you in this matter. You have now heard the proof in the matter of Curtis William Burkett and Burkett and Associates. You are the exclusive finders of the fact in this case. You are also the exclusive judges of the application of your rules and regulations governing private investigators. As the sole and exclusive finders of fact, you must conduct open deliberations, make findings of fact, and reach conclusions of law. You must determine the facts based upon the evidence presented, and based upon the facts adopted by the board, you must then decide whether the respondent's acts or omission constitutes a violation of the rules or statutes which the state has alleged in their notice of hearing. If you decide that a violation has occurred, you must then decide what disciplinary action, if any, is appropriate. You may censure, you may place the respondent's license on probation, you may suspend them, you may revoke them. All of the things that are available within your statute are what you are allowed to do. You may also assess civil penalties, and you may assess costs in this matter. But first, you will make your findings of fact as I instructed solely on the evidence that you heard. The notice of charges is not findings of fact. Now, you may use the notice of charges or any proposed findings of fact and conclusions of law as a guide only. If you decide to use those, you'll review them, and I will instruct you as you go along how to go forward with that. The state has the burden of proof, and it is the state's burden to establish all of the facts necessary to prove the violation that has been alleged in this matter. You must only make your decision based on a preponderance of the evidence. That's the amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by the preponderance of the evidence, a party must convince you that the allegation is more likely true than not. Once you have made your findings of fact, you will set forth your conclusions of law. You must determine which findings of fact apply to the law that you determine that is appropriate in this matter, and if the violation has occurred. Any motions to adopt your findings of fact, conclusions of law, or any other motions must be made by a simple majority. Once you've made your findings of fact, your conclusions of law, decided if a discipline is appropriate, you will then state a policy reason for your decision. The policy reason generally states why your decision in this situation is appropriate. Do you have any questions? Without questions, I'll turn the matter over to Madam Chairperson.
Like me to pass out a...
Yes, please. The state has proposed findings of fact and conclusions of law that you may use as a guide.
At this point, do we want a motion in order to get to the point of discussion on this?
I'd like to make a motion that we revoke the license for the individual under the evidence brought for us, or before us, under 62-26-22, or 221, Section 2, Madam Chairman.
Is there a second?
I'll second that.
Motion made by Commissioner, or second by Commissioner Horton. Discussion?
I think we need to determine the findings of fact first. And I think the findings of fact that has been outlined to us is sufficient, except for number 2. Staten actually paid the $500 to his attorney. The attorney then paid the $500 to Burkett, which I would like to correct in the findings of fact. Other than that, I would conclude the findings of fact and move on to the conclusions of law.
I'm not going to let you do it. What you have to do, because if you do it that way and it were to go up on appeal, nobody knows what you adopted.
Okay.
So if you will, what I suggest is you, and depending on the situation, but yours is pretty short, if you would like to read all of the findings of fact into the record and then adopt them collectively, but go ahead, like you said on number 2, and word it how you want it to read them all in, and then adopt them that way.
Okay.
That way you've just got a good, clean record.
Okay, our findings of fact then will be number 1, Respondent William Burkett is duly licensed by the Tennessee Private Investigators and Polygraph Commission, and Respondent Burkett and Associates Investigations is also a duly licensed private investigation company. Number 2, in June 2012, Roy Staten, the complainant, paid $500 to his attorney, Ms. Christy Anderson, who then paid $500 from her account to William Curtis Burkett, who accepted this for his investigative services, but failed to provide any findings to the complainant or the complainant's attorney. Complainant provided the Commission Office with a copy of the canceled check dated June 19th, 2012, in the amount of $500 from the complainant's attorney, made out to the respondent and its qualifying agent, William Curtis Burkett, and executed by the respondent's qualifying agent, William Curtis Burkett, which evidence the respondent's acceptance of such payment. Number 5, complainant states that respondent William Curtis Burkett refused to communicate and has avoided all contact and telephone attempts of complainant. Number 6, complainant's attorney, Ms. Christy Anderson, verified that no work was provided to complainant. Ms. Anderson further stated that the check was cashed and signed for payment by respondent William Curtis Burkett. She also stated that she has received no evidence of any work done by Burkett for this matter. Number 7, respondent William Curtis Burkett responded on behalf of himself and on behalf of respondent Burkett and Associates investigations and stated that the allegations were false, but provided no documents, reports, or contracts to support respondent's statements. That concludes our findings of fact.
That's a motion.
That is a motion for us, yes.
Is there a second?
I'll second that motion.
We have a second by Commissioner Horton. Any other discussion?
Well, we have 2 motions on the floor.
Yes, I withdraw the first motion that I made, Larry Flair.
Commissioner Flair has withdrawn the original motion. Any discussion? All in favor?
Aye.
Aye.
Opposed? Motion carries. Have a motion on the conclusion of law.
I would move that our conclusions of law are that, number 1, respondent's acts and conduct constitute a violation of Tennessee Code annotated 62-26-221, parentheses 2, which states in part, no individual licensed as an investigation company or private investigator in this state shall, parentheses 2, into parentheses, make unsubstantiated monetary charges to a client for services not rendered or transportation not utilized. Number 2, respondent's acts and conduct constitute a violation of Tennessee Comp Rules and Regs number 1175-04-06, parentheses 4, which states in pertinent part, parentheses 4, the licensee shall not bill a client for services or expenses which have not been provided or incurred. A complete and comprehensive itemized statement of the services and expenses must be provided to the client upon request. Number 3, respondent's acts and conduct constitute a violation of Tennessee Code annotated 62-26-217, A1, which states in pertinent part, A, the Commission may suspend, revoke, or refuse to issue or renew any license under this part upon finding that the holder or applicant has, 1, violated this part or any rule promulgated under this part. That is a motion on the conclusions of law, Your Honor.
Is there a second?
I'll second it, Madam Chairman.
Second by Commissioner Flair. Any discussion? All in favor?
Aye.
Opposed? The motion carries.
Now you must decide the discipline that you would like to impose, the discipline that the state requested as a guide only would be found in the notice of charges.
Your Honor, question, if you may.
Yes, sir.
Once we decide if we want to revoke or whatever, then what is the limitation, if you will, that this board could assess on the licensee?
As far as civil penalties,
Yes, ma'am, monetary.
you would find that in your rules and regs. Do you have your rules and regulations with you?
Want to,
Yes,
Okay.
let's look at, we'll get those for you.
Actually, this is in the statute, Your Honor.
Yes, ma'am.
6226-217, B, in addition to and in lieu of any other lawful disciplinary action under this section, the commission may assess a civil penalty not exceeding $2,000. That's on the revocation of license section of the statute.
Okay, thank you very much. Does that answer your question?
Yes, ma'am, and if you will, Your Honor, that is on per charge or per violation?
I think that's upon revocation of the license.
It sounded like upon revocation.
It sounds like it, that's how I read that statute, Your Honor.
Okay.
Thank you.
Yes, sir.
Your Honor.
Yes, sir.
What is the cost of this hearing?
The cost
How do you
will be the state will have a number of costs up until this point. Once the hearing is completed, then the costs of my services and the court reporters will be added to it. Generally, the costs don't exceed $5,000, do they? That's a good fair number that generally you don't see them exceed that price unless it's a really big hearing.
We have anything in our laws or rules that we could require a refund of the funds?
No, ma'am.
Be civil.
Bill, Madam Chair, that's beyond our boundaries.
Yes, sir.
On the civil part.
Yes, sir. Yes, sir. That's something that he would have to take up in court.
Madam Chairman, would it be proper now to make a motion, please?
Yes.
I'd like to make a motion that we revoked the license of the PI company. And do we need to do this separate, Madam Chairman? I'm sorry.
I would do it all in one.
Oh, yeah.
You can do them. They were filed together.
It would be the disciplinary action.
For the record, let me start the motion. I would like to make a motion. We revoke the license for both the company and the individual as a PI, or private investigator, I'm sorry, and access the $2,000 limit to the individual and all cost that up to the end of all proceedings.
Is there a motion by Commissioner Flower, second by Commissioner Jones? Any discussion?
Is Mr. Stanton going to get any money back?
That was my question, and that's what they had.
That's not within your purview. The only thing that you can do is, your authority is to take action on the license. Yes, sir.
Any other questions? All in favor of the motion?
Aye.
Oppose? Motion carries.
We will now make a policy statement. Yes, ma'am.
It might be, since we don't regularly do this, that they could use,
One of the,
again,
okay, you need some guidance?
Yes.
Okay. Generally, the statement, your policy reason states why you're doing what you're doing. And, the action of the board, as you know, is you take action to protect the health, welfare, and safety of the citizens of the state of Tennessee. So you may use that language, incorporate any language as far as the individuals that you govern over their licenses as far as private investigators. So you can include language along that line as well.
Valentine?
I would like to state our policy reason for the cause and action that we have taken today is that we are charged with making sure that the health welfare of the citizens of the state of Tennessee is done in a professional manner as far as the private investigation industry is concerned. And we have seen that this is a clear violation of common sense and the laws that we have all sworn to uphold in the private investigation world for the state of Tennessee. Therefore, I think that we are justified and charged with this responsibility and have conducted this in a reasonable manner in performance of our duties.
Now, that's a policy statement in the form of a motion. Okay, is there a second?
I'll second that, Madam Chairman.
Second by Commissioner. Any other discussion? All in favor?
Aye.
Oppose? Motion carries.
Madam Chairperson, this hearing's adjourned.
Thank you.